Section 15 Remedies. Section 15.1 Remedies. Upon the occurrence of any lease event and default at any time throughout so long as the period is continuing, the leaser may, and as its option, declare that the lessor is to be defaulted in by a written notice of the lessors, except for this lease shall, without any action on the part of the leaser, by automatically deemed to have been declared in default upon the occurrence of the lease event of default described in section 14 G and H, and any time thereafter, unless the lessor shall have the um, remedied all outstanding leases events of the default prior to the commencement of the exerciser of the leaser of any of its remedies. Therefore, the leaser may do one or more of the following, as the leaser in its sole discretion shall elect, to the extent of the permitted by law, subject to the compliance of mandatory requirements of applicable law, then effect any proceed appropriate for the country, any appropriate proceeds appropriate for court action of actions that either by law in an equity and to enforce permanent performance in the lesser of applicable covenants of this lease or covered the damages of the breach thereof. B. A notice of writing of the lesser to the leaser may demand the lesser, and the lesser shall have, upon written of the leaser at the lessor's expense, but of subject of the right of the sublessor, which is granted the right of to the quiet enjoyment of the unit of the lesser pursuant to the sublease so long that as no event of the default of the sublessor shall have occurred to the continuing under the relevant sublease. With return all that any part of the units to so demand of the leaser, or it's ordered in the manner of the condition required by and otherwise without notice by judicial process, may by its agent enter upon the premises of the lesser other premise is with any of the units may be located to take possession of or remove all of the units of the the leaser may use employ in connection with such removal of any surfaces and ads. Equipment, trackage, and other facilities of the lessor is responsible required to remove such units, therefore, and possess and enjoy some same free and any right of the lessor or its successor or assigns to use the units for any other purpose whatever, and to respect to any of the unit of subject subleases and assigned all lease rights and title interest into the sublease to the leaser. Sell any of the units assigned to the sublease at the public or private sale in such a manner that the leaser may determine free clear of any of the rights of the lessor by subject to the right of the sublessor, which is granted the right of the quiet to enjoy the quiet to enjoyment of the unit of the lessor pursuant to the sublease, so long as no event default of the sublease or sublessor shall occur to the continue under the relevant of the sublease without any duty to account this lease or any sublessors with respect to such sale the proceeds thereof except to the extent of the required paragraph below. The leaser elects to the exercises all its rights understood the paragraph in which the lesser obligation to pay the basic rent with respect to these such units here and under due to any period subsequent to the date of such a sale terminate, except for the extent of the basic rent is to be included in the computations under the paragraph E and F below. The leaser elects to exercise in its rights either by said paragraphs. D. Hold the keep idle and or other lease to others as any unit not to the subject to the sublease to this lesser is at any sole discretion may be determined free and clear of any of the rights of the lesser without any duty to the account of the lesser or sublessors with respect to such action and action for any proceeds with respect thereto, and expect the lessor's obligation to pay the basic rent with respect to such unit due the period subsequent in the date of the lesser shall have been deprived possession until of use of such unit in the section 15 shall be reduced to the net proceeds, if any, received to the leaser by the leasing such as the unit to any persons other than the lesser, whether or not the leaser shall have exercised or shall thereat to any time exercise any of all rights under paragraph A, B, C, and D and above will respect to the units of the leaser will write the notice of the lessor specifying a payment due to which day is the termination date of the proposed the computation stipulated by the loss amount, which shall not less than 10 days after the date of such a notice may be demanded by the lessor or paid of the leaser. To the lessor shall pay the leaser on the payment due specified in such a notice are liquidated damages, loss of bargain, not as a penalty in lieu of the basic rent for such unit due to the payment and specified units, all rent on other stipulated loss and amount and terminations amount calculated reference thereto and payable to the incurred in respect of such units and payment specified in such a notice exclusive on any basic due rent or basic rent due on such a date, plus whichever of the following amounts of the leaser in such a sole discretion shall specify in such a notice that an amount with respect to each of the unit represents the excess of the present value of such a payment date of all rentals of such a unit which would otherwise have occurred on her here under the such a payment of the remainder of the basic terms or in any renewal term and the effect of the present value of the fair market rent value of such a unit taking into account as actual conditions for such a period discounted for the end of such a term to such a payment date such as present value computed in each of the causing and using of a per annum discount rate equal to the debit rate compounded by monthly and respective dates upon the rentals which have payable here and under the lease not been terminated, or two, in an equal amount of excess, if any, stipulated loss amount of such a unit computed as payment and specified in such a notice that hereafter the fair market sales value of any such unit taking account as in the condition as the moment is specified in such a notice that 3. The leaser shall not have sold such a unit pursuant to the exercise of its rights under the paragraph C above with respect to the unit is an amount equal to the higher stipulated loss amount of the same unit computed as the payment date specified in such a notice of the fair market sales value of such a unit, assuming its condition is required by lease as such a payment specified in such a notice upon the payment of the lesser pursuant to the said clause 3 in such a stipulated loss of amount of fair market sales value as the case may be the late payment premium of all other amounts other basic rent due to the such a date payable as the lease under the lease and other operative agreements in respect of such a unit leaser shall transfer as is where is without recourse warranty all right title interest or lesser to such units to the less as well interest in the leaser to such a unit of the lesser of the any as it may direct the leaser to shall execute deliver and documents evidence such a transfer as the lease transfer as a lesser shall responsibly request. The leaser shall have a solid any unit pursuant to the paragraphs seen above the leaser in equal in lieu of the exercising its rights under the paragraph above the respect to such unit if it shall so elect demand the lesser to pay the leaser and the lease shall pay to the lesser and the lesser shall pay to the leaser a liquidated damages for the loss of the bargain, not as a permanent penalty in lieu of the basic rent for such a unit due to subsequent for the rent of the payment due to the next proceeding such a sale accrued to the unpaid rent of such a unit as the date of such a sale basic rent or proposing occurring at the per diem rate of equal to the monthly due to the next following rent payment date divided by 30 exclusive on the basic rent on due on such a date plus an amount in which the stipulated loss amount of a unit of such a unit computed as the rent date next preceding the date of such a sale if the sale occurs the rent payment date of the and computed by the sale, such a rent payment date plus the amount of the late payment premium exceeding the net proceeds of such a sale taking its account for the purpose of all costs and expenses including legal fees expenses incurred by the leaser in the connection with such a sales otherwise exercising remedies hereunder plus interest and other such excess for the date of such a sale to the date of the payment at the late of the rate. And the leaser may terminate the leasing at any time, leasing of any of all units under this lease, and if any sublease is expecting with respect to the sublease with which grants the sublessor there under the right to quiet enjoyment within respect to the unit, so that long as no event and the default of the sublessor shall have occurred by and continuing under the relevant sublease may exercise any other right remedy to the room may be available to the under applicable law. In addition, the lessor shall be liable expect otherwise provided above for any of the all unpaid rent due to here and under during before and during the exercising of the foregoing remedies, including without limitation late payments, interest plus exclusive of any basic rent due on such a day for the legal fees, interest but exclusive basic rent, and for the legal fees and other costs expenses incurred by the rent incurred by the reason for the occurrence of any lease event of default of the exerciser of the lease or remedies with respect thereto, including with the limitation of the repayment in the fill of any costs and expenses necessary to be expended in repairing any unit in order to cause it to be in the compliance with all maintenance regulatory standards imposed by this lease. In the event of the leaser terminates this lease pursuant to any provisions of Section 15.1, the stipulated loss amount is not payable. The amount otherwise payable by the lease here and under shall be increased by any positive payment and the payment for accrued by unpayment basic rent for the basic rent adjustment set forth by Schedule 4A participation agreement opposite for the relevant rent payment date decreased by the absolute values of any negative amount as in the rebate of the prepared basic rent as the basic rent adjustment as set forth by the Schedule 4A of the participation agreement opposite for the relevant rent payment the date provided however thereto extent there such payment refunded does not proceed it reflects the difference between the basic rent allocated with the basic rent paid as the date of the basic rent ceased to occur the amount of the date due hereunder shall be adjusted to ensure that the agreement of the amount of the basic rent is paid equal to the agreement of the amount of the basic rent allocated as the date of the basic rent ceased to occur. 15. Cumulative remedies. The remedy in this lease provides in favor lease